So I would like to give the floor then to Edina, who will present this paper entitled Beyond Data Protection, the Effects of Other Technology Law Reforms on Data Protection and Commercial Data Transfers. Thank you very much, Edina.
Thanks very much, Eduardo, for the introduction. I hope you can see my slides that I've shared. I can see that it appears to me that they have been shared correctly. So what I would like to talk about is will sort of build on what Karen has helpfully explained and laid out in her talk about adequacy. So I won't go back and re-explain something that I can definitely not explain better than Karen. But I will move beyond just the data protection reform in the UK and the consultation, looking at other areas of tech law, in inverted commas, that are ongoing or upcoming in the UK and that might impact or will definitely impact human rights, the right to privacy, data protection, and potentially adequacy decision. So this is the outline of my talk, and I'll try to be as concise as possible and to leave time for discussion and the break as well. So I'll just talk about the online safety bill reform, the ongoing online safety bill reform. The bill is in the second reading in the House of Commons as we speak. And then the Human Rights Act reform that is the consultation for which is closed, and we as Belita have submitted response as we did for the online safety bill and the data protection as well, and many of you have participated in those, and I thank you. And finally, the AI strategy or the AI regulations and reforms. So I'll try to chart what I see at the moment. As I said, this is very tentative, so I might be missing something, and I will hope that you will correct me or just add something to this. I will try to see whether there is synergy between these four reforms. Maybe I've missed an important reform that you will flag, or there is a divergence in some form between those when it comes to privacy and data protection in particular. So again, not repeating what Karen has said about adequacy, about her helpfully explained four dimensions of adequacy and what it means for the UK. I would just like to mention specifically here the recital 277 of the adequacy decision, of the UK adequacy decision, that talks about and Karen has mentioned this in her slide, but didn't really go in detail because probably she didn't have much time, but meaning that any data protection regime or the legal system needs to adhere to the European Convention of Human Rights and submit to the jurisdiction of the European Court of Human Rights that we do at the moment. So that's important to flag when we talk about other reforms such as the Human Rights Act reform. And what I've highlighted here is that continued adherence to such international obligations is a particularly important element of the assessment on which this decision is based, or any future decision revisions, revocations might be based. So if there is a divergence in particular with regards to this broader commitment, but also with regards to what Karen has mentioned and two particularly problematic proposals in the data protection consultations about research and legitimate interest that we also as Belita flagged in our response, will the UK be able to obtain periodical review of a renewal of the adequacy decision or not? If the Commission is ready to look beyond just the data protection reform, if that's okay, and now there is a huge question mark if the data protection reform will be compatible and adequate, but then there are all these other reforms that might impact adequacy, in my opinion. So the first one is the online safety bill that I will briefly explore, and then the Human Rights Act reform. I won't talk about data protection reform because there is too much to say about that, and Karen has started that discussion, and I hope we'll explore that, of course, more in detail in my full paper. And then finally, AI strategy and regulation in the UK. So with online safety bill, my favorite topic, I've written quite a lot and spoken to the parliament and tweeted about that quite a lot. So the online safety bill geek, just a simple search on the bill that's introduced in the parliament this month, last month, sorry, in March, mentions data protection 5 times on 225 pages. And that is when it talks about the disclosure of information to Ofcom by the platforms, by the companies that are regulated, the services. And then personal data 11 times. And some of these times that he mentioned, personal data is within this duty in clause section 19 of the bill. That is a cross-sectional duty, and that is duty about the freedom of expression and privacy. And there, the online safety bill also talks about the compliance, the need to comply with any provisions of the data protection law. So when the platforms or the regulated user-to-user services and search engines fulfill their duties under the bill, the online safety bill, they need to have a regard, as the bill says, of the freedom of expression and privacy, and there within privacy data protection. So this is where these are the only places that the online safety bill mentions data protection. And in my view, this is inadequate and insufficient. And of course, there is a lot of room for Ofcom to explore this and as the regulator, future regulator, and to develop this in the codes that they will draft. And one of the codes will be about freedom of expression and privacy. So I wonder what provisions about data protection will be there, and how will this then impact? There's a lot of uncertainty on how this could impact then the data protection regime as a whole and adequacy decision. My particular concern is the potential consequence of the bill is that the platforms will conduct a proactive monitoring of personal data. So Article 15 of e-commerce directive, of course, will not apply. And to comply with their duties of care, duties to deal with illegal and harmful content, they will need to proactively, they're likely to proactively monitor personal data as well, and that could be problematic from the data protection perspective. So this is just very, very brief and sketching of what I think about the online safety bill and the impact on privacy and data protection. The further reform, a massive reform of the Human Rights Act. There is of course, rights in capital here, sorry. Human Rights Act reform, consultation closed recently again. Unfortunately, the Human Rights Act reform, again, does not really talk about privacy or data protection a lot, or very insignificantly and inadequately. It mentions privacy 7 times within the consultation documents, and mostly within balancing acts and balancing against freedom of expression. There is no mention of data protection in this document, apart from the Appendix 1, when it talks about the article, ECHR Article 8, and how DPA and UK GDPR are statutes that serve as one form of protection of privacy. So that's the only way. These are the only places where privacy and data protection are mentioned, unfortunately. So again, the data protection reform is not considered important to be included here, or to be sort of balanced and considered as a holistic sort of approach to a law reform that we would like to see. Just to show you those examples where I see hostility in this reform, Human Rights Act reform, towards privacy and data protection, ironically, in favor of freedom of expression, which is contrary to the online safety bill, where in our view and the view of a lot of commentators, there is hostility towards freedom of expression. So in this reform, and you can see the paragraph 206 from the consultation document, the government says that the Strasbourg court has shown willingness to give priority to personal privacy over freedom of expression, which in my view is a complete nonsense. And then also continuing to say that the so-called right to be forgotten was invented by the Court of Justice of the European Union, as if it's not in the GDPR and in the UK GDPR. So this is one of the examples where, in the government's view, in a case where Strasbourg Court has given precedence to privacy over freedom of expression, and this shouldn't be happening in the post-Brexit UK, basically. Also, there's what I highlighted here from this document is that government does not believe that principles and balancing acts between the rights should be merely left to the courts, but there should be a presumption in favor of freedom of expression. Okay, so this right has been given more weight, contrary to the jurisprudence of the Strasbourg court, and these exceptional countervailing grounds to freedom of expression should be clearly spelled out by the Parliament in the new Human Rights Act. Again, problematic for many reasons and departing from jurisprudence of the Strasbourg court, in my opinion. Okay, again, a very, very brief sketch in the interest of time of the Human Rights Act reform and what I thought was the most important and most problematic in terms of the consultations. With regards to AI, future laws and regulations, looking at the national AI strategy, it does state that it supports propositions in the consultations data new directions. So the data protection reform, it states that the AI strategy should be in line in any future AI regulation as well. And the short-term goal is to determine the role of data protection in wider AI governance following the consultation and the data protection law reforms. And then in one of the priorities around trade, the AI strategy emphasizes the importance to champion international data flows, preventing unjustified barriers to data crossing borders while maintaining the UK high standards for personal data protection, so onward transfers. And again, in line with the new data protection framework, whatever it will be, but potentially problematic if when we see what it is from the perspective of adequacy, and could impact adequacy as well. But at least this area is sort of aligned with another reform, which is a data protection reform, which is not the case, as I said, with the online safety reform and the human rights reform. So my tentative conclusions here, and if I may add to Karen's framework, and she can disagree, okay, and this just came to my mind when I heard her talk today, but in addition to her 4 dimensions of adequacy, I would maybe squeeze in the 5th, which is the cross-sectoral dimensions, looking at these different sectors and how they impact data protection law, and given the commitment to comply with the human rights framework established by the ECHR and the Strasbourg Court jurisdiction. So the cross-sectoral, in my view, the cross-sectoral dimension is also very important, and maybe could be a sub-dimension within Karen's definitional and operational dimensions, just an idea. So what I tentatively and very crudely, clumsily perhaps, conclude here is that online safety bill as it is now has a potential to harm both privacy and freedom of expression for many, many reasons that I've written about, and some of them which I've mentioned. The second law reform, data protection reform, could potentially harm data protection rights and the privacy rights of the individuals in the UK if all the proposals are adopted in the end. The Human Rights Act reform champions free speech, ironically, over privacy, contrary to online safety proposal. and the AI strategy and potential law reform could, again, in line with the data protection law reform, harm data protection rights and privacy. So what I suggest is that in accordance with the decision and the adequacy decision and GDPR, adequacy should be assessed beyond just data protection reform, looking at all of these reforms. But the question arises whether Commission has the ability and capacity to assess all of these reforms, and whether the government will notify the Commission and this process that exists within the adequacy decision. In practice, I think that it's as is shown already today briefly, but if you study those law reforms in more depth, they have not been coordinated well within the government, which is not surprising if we know who the government is and the ministers, etc. But this lack of coordination between these different sectors and reforms will result, in my opinion, in the divergencies that may impact privacy and data protection and potentially adequacy decision and cross-border data flows. And I'll finish here. Thank you.